So good evening, everyone. Welcome to this webinar, and this will be a series that we're launching shorter sessions focused on a very particular subject. Today's subject is of immense importance for all insolvency professionals and people who are interested in the insolvency framework. And I believe this subject of what is due towards workmen and employees is a very critical issue that is very important in all CRP cases. So I will ask Anil sir now to start his deliberations on this very important topic. We have a good number of participants today, and it is increasing as we speak. But I think we can start since this is a 1-hour session.
Thank you very much, Ankit. It's indeed a pleasure for us again to reconnect with our listeners and viewers. We took this opportunity when this new judgment was delivered by Honorable Supreme Court on 19th of April 2022, and this was much awaited because in most of the cases these disputes are pending. I believe any committee of creditors or any IRP, RP or liquidator, they were struggling with these issues, and a lot of litigations were pending in different NCLT and NCLAT benches. Therefore, now this judgment of Sunil Kumar Jain versus Sundaresh BHATT, and in the case of ABG Shipyard Limited, this is a settled position now, and we will go through this judgment today, and it is our endeavor to get connected with our viewers. Not only this, every Sunday, we commit every Sunday at 4 o'clock, we would be coming with any subject which is a hot subject, and the sessions would be not very big, it will be smaller sessions. So today's session is only focused on this judgment, which is very important. I'm just sharing my screen. Give me a minute. So I hope, Ankit, my screen is visible.
Very much.
Okay, so you see the judgment is, as we say, that we are now coming up with a webinar series, and this is episode 1. We have named it as Decoding the Honorable Supreme Court Judgment in the name of Sunil Kumar Jain and others versus Sundaresh BHATT. And this was pronounced on 19th April 2022. So, friends, the importance, of course, will definitely, during the process of this webinar, we will understand the importance of this judgment. According to me, various issues have been settled. So we'll be covering the methodology that we have adopted is like what is the impugned order and what were the arguments of appellants, then what are the law relied by the appellants, then arguments of the respondents, then what were the issues framed by the Honorable Supreme Court, relevant provisions of law, legislative history, and observations and Honorable Supreme Court, and way forward for all the IRP, RP, liquidator, and the committee of creditors. Very important roles have been given to the IRP, RP, and the committee of creditors, very important roles. And it is not something that I'm exaggerating. It is the text of the judgment says like that in future regarding the workmen claims and regarding the status of going concern of the company, that is a very key issue, and that has to be managed within the very first, probably very first meeting in case the information is available. See, coming to the, see, as we know, this judgment, it was delivered by Honorable Justice M.R. Shah and Justice ANIRUDDHA BOSE, and the law has been settled in a very detailed manner. The duties have been casted upon the IRP, RP, liquidator, and the COC. Now, in this case, this was a case of ABG Shipyard Limited, where the CIRP started on 1st of August 2017 and ended on 25th of April 2019. So the CIRP continued for 20 months and 25 days. Original order passed by NCLT Ahmedabad in this particular matter, which was the matter relating to the workmen's dues, that was passed on 25th of April 2019. And what are the facts of the case? The facts of the case were, in this particular case, when the CIRP started, there was 562 workmen and 93 employees was actually on the roll of the company at the Hage yard of the company. Then 291 workers and 99 employees were actually available. They were on roll at Surat, and 101 employees were on roll at Mumbai office. Now the adjudicating authority, in fact, did not grant any relief to the appellants, who are the workmen and employees herein, and with regard to their claim relating to the salary wages, which they claimed for the period involving CIRP and prior period. So there are two scenarios. One, the claim of workmen and employees for the period prior to commencement of CIRP. Second, the claim of the workmen and employees during CIRP. So this was the matter. So as far as the claim of workmen and employees is concerned, that's primarily settled, because it will be dealt with according to section 53 and subclause 1B and C. Whereas the main dispute was like the workmen and employees who were on roll of the company as on the date of commencement of CIRP, which the RP did not terminate. There was nothing on record to say that their services were terminated, whether they are entitled to their salaries for this period or not. So this was the main issue. So the impugned order, which was the ANCLAT order, ANCLAT disposed of the appeal and said that we do not want to interfere in this order of adjudicating authority. And they in fact, the ANCLAT said that the 272 workmen and employees, they have to file their individual claims before the liquidator. So there were conditions for this individual claims. NCLT further observed that if the claims of one or other workman employee is rejected, it will be open to them to move before the adjudicating authority. That was a smaller issue. Like anyone's claim, if it is rejected, they have power to go to adjudicating authority. ANCLAT also observed that so far as the gratuity fund, provident fund, this is regarding section 36 subsection 4, regarding the gratuity fund, provident fund, and superannuation fund, and it was held that these funds cannot be considered as the assets of the corporate debtor, and the liquidator would not have any right to take over the money which is lying in the gratuity fund, provident fund, and superannuation fund. So this was the impugned order which was argued before the Honorable Supreme Court. So let me first of all go to the basic primary issues in this case. And the primary issues in this case was twofold. One, these were the issues before the court. One, the claim of workmen and employees with respect to wages and salaries during CIRP period. And second, the amount due and payable to respective workmen, employees towards pension fund, gratuity fund, provident fund, in view of section 36, subsection 4 of the code. These were two primary issues before and I understand, and in various cases, these two are the key issues for various litigations. So the arguments by the workmen, arguments by the employees, it is very carefully, you have listened, that all was primarily in their favor. All the arguments were in their favor. That was, first, for the entire period of 20 months and 25 days, the respective employees and workmen were on payroll of the corporate debtor. That means they were not terminated. Their argument, which was even valid, it was also confirmed by the liquidator and who was also the erstwhile RP, that the RP did not terminate the employment contracts and or retrenched their services, or layoff was not also done. Rather, at the top of it, RP issued instructions which was dated 4th of September 2017 to all the employees and workmen to report to him and follow his instructions. Further, on 15th of November 2017, RP issued an email to HR department of the corporate debtor instructing strictly not to relieve or permit resignation of any employee workman without written approval. Now, further see the arguments in favor of the workmen and employees. The corporate debtor was managed as a going concern in accordance with Section 21 of the IB Code. That's of course obvious. Every RP has to manage the company as a going concern. Even the proposal to suspend operations at the Dahej yard and provide workmen with paid leave was rejected by the Committee of Creditors for lack of majority. This particular resolution also was not passed. In case we see Section 28, in the change in the terms and conditions of the workman and employee is within the powers of the Committee of Creditors under Section 28. Therefore, the RP probably decided that the operations at the Dahej yard of ABG Shipyard Limited should be suspended, but that was not approved by the Committee of Creditors. Coming to the further argument, which was in favor of the worker and employees, that throughout the CIRP period, the employees and workmen of the Dahej yard were asked to assemble at ABG enclave and sign the attendance register. Since the transportation to yard was discontinued by the RP may not have money, the transportation was not arranged, since there was no work at the yard. So the RP also decided to mark their attendance. They were marking their attendance at ABG enclave, where an attendance register was kept. Now, further, look at the argument which was in favor of the employees and workmen, that throughout the CIRP period, the employees of Mumbai office had regularly attended the office, recorded their attendance with the attendance reader installed at the Mumbai office. In some cases, even the proof of work done by the respective employees, workmen during the CIRP period was also placed on record. Further, during liquidation, the claims filed by the employee workmen in Form E with the liquidator have been verified for CIRP period on the basis of the records available, including the attendance register, have been uploaded by the RP liquidator on 24th of December 2020 on the official website of the corporate debtor. Now, in this case, the claim is accepted. The proof that they were working, the attendance is also available. Even if the attendance was not available at the yard, but it was available at ABG enclave. Look at the company was a going concern. Their employment contracts were never retrenched. In fact, they were instructed to report to the RP. So all this was the arguments in favor of the workmen and employees. So therefore, based on these facts and circumstances, the workmen and employees, they claimed that for the entire period of CIRP, which is 20 months, 25 days, their salary and wages should be paid in full, and it should be considered as CIRP cost. So the basic issue is that for this 20 months and 25 days, the wages and salaries should be considered as CIRP cost, which may become huge because the total workmen was about 1,000. They also argued the second issue. The second issue was that they also argued that as regards provident fund and gratuity and pension fund, they should be paid. They should be paid in full, because this money, whatever this money, that is not part of the liquidation estate under Section 36, subsection 4 of the IBC. So they were claiming these two things, and these two things, in fact, was the basic issues in this case. RP and the liquidator had clearly provided the cost on account of the employees and workmen under the head other services in a running concern. As you all know, that the RP and the liquidator, they are supposed to upload the CIRP cost in Form 1, 2, and 3 to IBBI. And RP and the liquidator had been uploading the cost of the employees and the workmen to IBBI website. That means that the RP and the liquidator, they were accepting that this is the CIRP cost. And it was because, as you know, this is required by all the employees, all the RPs and liquidator, that they have to upload the CIRP cost via the IBBI circular dated 12th of June 2018. So this was also uploaded as a CIRP cost. Now look at all the arguments in favor. All the arguments in favor. Therefore, they were saying that the salaries and wages due payable to the employees, and this should be considered as CIRP cost. This was the main argument. Also, the prior period salaries, that should be paid as pari passu. There was no dispute about it, and it is all the amount which is about 16.8 crores of which was disputed. So these are the basic law which was relied by the appellants. The definition of workmen, well, said the definition of insolvency resolution process cost, which also says that the any expenditure incurred by the RP during CIRP period that would be considered as CIRP cost. Definition was also given for CIRP, yani the corporate insolvency resolution process period, the definition of personnel. The section 17 was also relied by the Honorable Supreme Court, management of the affairs of the corporate debtor by IRP, duties of IRP, the personnel to attend cooperation to IRP, management of the operations of the corporate debtor as a going concern, duties of the RP, and then the section 33 subsection 7, where it is said that the order of liquidation shall be deemed notice of discharge to workmen and employees. This was also discussed. And of course, section 36 subsection 4, where it is very clearly said that the any money kept in provident fund, superannuation fund, or gratuity fund would not form part of liquidation estate. And of course, section 53 was a relied waterfall mechanism. The different sections like section 53 1A, B, and C were basically in the discussions. Now let us see after even accepting their claim as CIRP cost, after directing them to work, after directing them to report to him, after directing them to mark their attendance, some of the workmen also working with them. So these were the arguments of the liquidator. Of course, at the instance of the COC, that the workman and employee have done no work. The argument of the liquidator at the instance of the COC, that could have been COC only because the liquidator was the erstwhile RP, and then the liquidator also accepted this money as this amount as a CIRP cost. Liquidator also uploaded the CIRP cost, the details of the CIRP cost to IBBI. However, this particular fight, I think it was primarily at the instance of the COC, when the COC, then the liquidator said in the court that the workman and employee have done no work during the CIRP period and have not assisted the RP liquidator during the CIRP, would not fall within the parameters of CIRP cost within the definition of 513C. 513C, in case we see 513C, it is actually very clear that this is what is the 513C. I believe it is readable. This is the insolvency resolution process cost, and it says any cost incurred by the RP in running the business of the corporate debtor as a going concern. So the liquidator was relying this now at the instance of the COC, that it is written that in running the business of the corporate debtor as a going concern, it is focused only on any cost incurred by the resolution professional in running the business of the corporate debtor as a going concern, and not simply because they were on the roll. Then the liquidator said in the Supreme Court that only 8 employees at the Mumbai location for 8 months during the CIRP, and workmen employees from Surat from August 17 to October 17 assisted the RP in providing services required under the CIRP process. 8 employees from Mumbai, and some of the employees or maybe all employees during August 17 to October 17, maybe that particular yard was working at that time, and the remaining employees and workmen, including the appellants herein, were not required to and did not perform any service to run the corporate debtor during the CIRP. Now that the COC of the corporate debtor rightly did not approve the payment to the appellant, in many cases the COC is not approved it. The question is that the COC has also not terminated. COC has not approved their cost as CIRP. However, the RP has uploaded this as CIRP cost. RP must have been providing these details of every month, the cost of the employees. RP has been uploading this as CIRP cost in form 1, 2, 3, and it was being uploaded to IBBI. And the COC in this case has not approved the payment. This was the argument of the liquidator. Further, as far as this workmen and employees would fall, then it was said that this particular the salary and wages of the workmen and employees during this will fall under section 53(1)(b). Now, when we look at the claims, whenever we look at the claims of the workmen are supposed to be submitted as on the date of CIRP, in case we only talk about the CIRP. they cannot. As on the date of CIRP, they cannot claim for future salaries. But when they file their claims during liquidation process, then they can also add their claim to the liquidator for the work that they have done during CIRP period. So there are two types of claim. One, that they are filing as on the date of commencement of CIRP. Second, that they will file as on the date of commencement of liquidation. Now, as of the date of liquidation, they will file their claim, and the liquidator says that will be dealt with in section 53(1)(b) and 53(1)(c). For the sake of ready reference, I will even take you to section 53(1)(b) and 1(c). Now, let us see section 53, which is regarding distribution of asset. Section 53(1)(b) says that the workman's dues for the period of 24 months preceding the liquidation commencement date, that shall rank equally between amongst following workman dues and the secured creditors. So this is what is B, and as far as the C is concerned, which is and any unpaid dues towards the owed to employees other than workmen for the period of 12 months preceding the liquidation commencement date. And the liquidator was not saying that this is part of the CIRP cost, and it will be admissible under 53(1)(a). So the only question was whether it falls under section 53(1)(a) or it falls under section 53(1)(b) and C. So finally, these were the arguments given by the liquidator, that it will fall under section 53(1)(b) and 53(1)(c). And then it was said by the liquidator that section 513(c), which we have already read, what this is the definition of the CIRP cost, and also read with the regulations 31 and regulation 33 of the CIRP regulation. Cost incurred by RP in running the business of the corporator is required to be ratified by a committee of creditors for it to be classified as CIRP cost. Now, in this case, although now the liquidator is saying that, but I believe the liquidator has done a couple of things. One, the liquidator has uploaded the CIRP cost to IBBI. I'm sure that the liquidator must have been submitting some reports to committee of creditors. Then only the liquidator would have uploaded the cost to IBBI. Secondly, liquidator has actually did not terminated them or did not even laid off to them, and also to retrench them. That was not done. Rather, the liquidator has made arrangement for their attendance, and they were making attendance. Rather, liquidator has said that they were attending to the office of Mumbai. So this was all. Despite all this, now the liquidator is saying that the cost was not ratified by the COC, that only the cost for those employees who have assisted the RP during the PI period have been approved by the COC in the first COC meeting held on 4/9/2017. And therefore, no other cost can be classified as CIRP cost except unless ratified by the COC. Now, the liquidator further says that as far as the remaining dues are concerned, that will fall due under section 53(1)(b). We've already seen that section. And the liquidator said that it was specifically recorded in COC minutes that the Dahej shipyard is not operational and that the corporate debtor is not in a position to pay the salaries of the workmen and employees due to paucity of funds, since the corporate debtor was not a going concern and did not have a running business. So it may have been recorded in the COC meetings that the Dahej shipyard is not operational and the corporate debtor is not having any money to pay. That is what I'm sure that in most of the cases when the COC is not contributing for the workmen, it is always recorded that the money is not being paid because of the paucity of funds. So it is also now said that this Dahej yard was not operational since 2015, and the yard at Surat was closed in October 2017. That is the reason that for about 3 months he said that this was operational, and therefore it cannot be said that the corporate debtor was a going concern during CIRP, and therefore all its employees would be required to be treated as those who assisted would not be required, assisted to run the company as a going concern. The liquidator further said that first the appellant was saying, the workers were saying that the Mumbai employees were attending to the Mumbai office. Now the liquidator is saying that as such there is no evidence to suggest that the respective workmen employees deployed at Dahej yard and Mumbai have actually worked during the CIRP. No, it is the question whether the attendance was important or actual work was important. You will see that the Supreme Court has said that the work was important. It was not the attendance. So even if the RP, even if the RP has taken the attendance, even if all the arrangements were made for their attendance, even if some people were visiting the head office, but then Supreme Court has finally said that it is the importance is the work, importance is the whether the services were utilized or not. This was also held. This was also held in a Jet Airways case, and if they had also gone for appeal, I think all these cases would be settled because of this judgment. In the case of SUNIL Kumar Jain versus Sandaresh, but the RP liquidator further submitted that the cost incurred during CIRP period by the CD or RP will qualify as CIRP cost only with respect to cost incurred by the RP in running the company as a going concern. That is what section 15 subsection 3 clause C says, along with the regulation 31, 33. When we see this regulation 31 and 33, I think for ready information, I may even bring before you what exactly section regulation 31 says. It only says in insolvency resolution process cost and shall mean amount due to supplier, amount payable to authorized representative, out-of-pocket expenses, amount due to any person whose rights are prejudicial, expenses incurred on or by the IRP to the extent ratified, expenses incurred on or by the RP fixed under regulation 34, other costs directly related to the corporate insolvency resolution process. So it is not referring to anything which is with regard to the going concern. Then we also read regulation 33, cost of interim regulation. This is also the appellant shall fix the expenditure, adjudicating authority shall fix. So this is also something which is not specifically referring to the expenditure for keeping the company as a going concern. However, the Supreme Court has regularly said that the definition of the CIRP cost is governed by section 5, subsection 13, clause C, and regulations 31, 33. So the corporate debtor is, it was also, liquidator was saying that the corporate debtor was neither a going concern nor RP has incurred any cost. Now, these are the issues before the Honorable Supreme Court. How to handle the claim of the workmen for who were on roll as on the commencement of the CIRP, and their claim for salaries and wages during CIRP period, which they were claiming that should be considered as CIRP cost and should be paid in full, and whereas the liquidator is saying that it should be paid pari passu along with the secured creditors under section 53(1) clause B and clause C. Clause B is for workmen, clause C is for employees. Then the second question was the how to handle this section 36 subsection 4, where it is said that the any money in pension fund and gratuity fund and provident fund that would be outside the liquidation estate. Now the Supreme Court had actually gone while making observations. They have actually narrated the legislative history. First, they touched the Companies Act 1956 and Section 59 capital A and Section 529 capital A subsection 1 and clause C, and where it was said in that sections that workmen dues and the debts due to the secured creditors shall be paid in priority to other debts. Further, it was provided that in the case of insolvent companies, winding up shall be undertaken in terms of the laws of insolvency with respect to the status of persons adjudged insolvent. That was section that was Companies Act 1956. So it was also, there was a proviso which said that the workman shall deem to have pari passu charge in favor of his in his favor to the extent of workman's portion. It further stated that where secured creditors, instead of relinquishing, is enforcing his security, the debt due to the extent of workman's share portion in the security shall rank pari passu with workman's due. It was said in the Companies Act 1956 that the workmen and the secured creditor shall have pari passu rights on the assets of the company, and even if they were not relinquishing, they would exercise their rights subject to the workman's dues on a pari passu basis. Then this particular amendment was brought by way of a Companies Amendment Bill 1985 with the objective to introduce necessary legislation for the legitimate dues of the workmen so that it should rank pari passu with the secured creditors in the case of closure of the companies. Further, They also started looking at Companies Act 2013 and Section 326 and 327, which said overriding preferential payment, and preferential payments were introduced, wherein a proviso to Section 326 of 2013 Act was inserted. Initially, the insolvency process in the case of binding up of insolvent companies were provided under Section 325 of the IBC of 2013 Act. Of course, however, when this insolvency law came in force on 15th of November 2016, at that time, Section 325 was omitted. And further, it was also amended, like this Section 327 and 326 will not be applicable in the event of liquidation under the IB code. So that means that whatever was provided in Companies Act 2013, now it all has to be handled under the insolvency law. Now here is the important part, the observations of the Supreme Court. Observations by the Honorable Supreme Court, let's see very carefully, because this, in each line, you would see that the new duties are being casted upon the RPs and the COC. Now let us see the first observation. While considering the claims of concerned workmen and employees towards the wages, salaries payable during the CIRP, first of all, it has to be established and proved that during CIRP, the corporate debtor was a going concern, and that the concerned workmen and employees actually worked while the CD was a going concern during CIRP. So the first thing, it is basically, it has to be established and proved that the CD was a going concern and the employee and the workman, they actually worked during CIRP. Now, what is up to this is, first of all, in the very first COC meeting, the committee of creditor has to take a decision along with the IRP, that whether the company is a going concern, what part of the company is a going concern, what part is operational, what part is closed, and also the list of employees and workmen and who are working at what location and what are their roles. That's a bigger duty now on the IRP and the committee of creditors. In case they would not do that, that means they would be incurring unnecessary CIRP costs. In the very first meeting, I think this is very important, that this chart of employees and workmen is made, that too at location wise, that too the operations of the company also has to be seen. The going concern status has to be seen. This is the very first duty. It has to be proved. It has to be proved that they actually worked. So you can't simply take the employees. The IRP cannot simply say that these are the employees on the roll. So it has to be established that they are actually working, and it has to be established that the company is a going concern at that particular level, whatever the status of the going concern is. Second observation. The wages and salaries of all workmen and employees of the CD during CIRP who actually have not worked or performed their duties when the CD was a going concern shall not be included automatically in the CIRP cost. So first is the positive, then the second is that it will not be included. First is how it will be included. Second, how this is negative, that it will not automatically be included in the CIRP. So every workman who would have a claim on the CIRP cost would actually have to approve that he worked, and he had the approval of the IRP and RP and the COC. This is something which is a new duty on the workman, also on the committee of creditor also. Only with respect to those workmen and employees who actually worked during CIRP when the corporate debtor was a going concern, their wages, salaries are to be included in the CIRP cost, and they shall have the first priority over all other dues as per section 53(1)(a) of the IB code. So that means it is a further clarification that anyone who actually worked, that salary and wages will have to be paid on the first priority. Of course, this is an automatic conclusion. In case they are working, then it's a CIRP cost. Any other dues towards wages and salaries of the employees, workmen of the corporate debtor shall have to be governed by section 53(1)(b), section 53(1)(c) of the IB code, even if they continue to be on the roll. Their salary would become due, but their claim would be accepted under section, their claim would be settled under section 53(1)(b) and 53(1)(c). In 53(1)(b), as pari passu with the pari passu with the secured creditor, and in case 53(1)(c), which is for employees, they would only get their salary for their dues even prior to CIRP or during CIRP, in case all the secured creditors are paid along with workmen. Then only the employees will get. So the employees are the worst hit. Employees are the worst hit. Section 53(1)(c) is after the CIRP cost, liquidation cost, and after the secured creditors are paid in full and the workmen are paid in full, then only the employee comes. So if any employee is working during CIRP, the employee should also assure that his work is approved, the COC has approved his retention, and that he's performing. Then only his salary would be considered as payable on priority. Otherwise, the employees who are working during CIRP period will not get, in case the secured creditors and workmen are not getting in full. Any other interpretation would lead to absurd consequences and violate the scheme of Section 53, read with Section 5, subsection 13. This is what is the observation of Honorable Supreme Court, that any other interpretation, and now the other interpretations could have been that anyone who is on the roll, that would be considered CIRP cost, because they were not terminated and they have not worked anywhere else, so they should have been paid. But now in this case, after this judgment, the employees would be cautious, IRP, RP would be cautious, the COC would be cautious, and they would be taking all appropriate actions only because this judgment has come. I mean, so far, in case we've gone through 3,000 resolutions, in each and every case, this particular anomaly was going on, and nobody knew who would be entitled to. And now I'm actually taking you through a such scenario that it might be even applicable to all the existing cases. It might be even applicable even to existing cases. Now let me go to that part. So let us see the next observation of the Honorable Supreme Court. If any other interpretation, more particularly the interpretation convest on behalf of the appellant, is accepted, in that case, the wages, salaries of those workmen and employees who had not worked at all during CIRP shall have to be treated or included in the CIRP cost, which cannot be the intention of the legislature. Further observations of the Supreme Court in this case is, however, still the claims to be submitted by the appellant will have to be adjudicated upon. Now, this part is very, very important. Now, the Supreme Court has further given a duty now to the liquidator. Now, let us see the duty of the liquidator, which has been, the liquidator has been directed to do, what the liquidator has been directed to do in this case. However, still the claims to be submitted by the appellants, means workmen and employees, will have to be adjudicated upon and considered by the liquidator, and the liquidator has to adjudicate and consider, number one, whether the corporate debtor was a going concern. This is the first duty now he has been directed to do. Number two, how many workmen and employees actually worked during the CIRP while the corporate debtor was a going concern. So these are the two things that the liquidator has been directed to do. So the liquidator will take all the claims of the employees and workmen. Liquidator will see whether the person, he was working in what part of the corporate debtor, whether that part of the corporate debtor was kept as a going concern or not, and whether that particular person worked during the CIRP period or not. This is a new duty is now casted. When the CIRP finished in 2019, the liquidation is going on, and the liquidator is now doing the fresh assessment of the claims of the workmen and employees for the period of CIRP. So this is a new duty on the liquidator. And in case we copy this spirit, into all other cases, that means that all the liquidators are supposed to do this while accepting the claim of the workmen and employees for the CIRP period, or in some cases liquidation period, where the liquidation where the company was kept as a going concern during liquidation. Also, this is the new duty of the liquidator, to accept their claims, to understand what part of the corporate debtor they were working, whether that part of the corporate debtor was a going concern, whether this particular person has actually worked during CIRP period, and also in case we copy the same spirit to the liquidation as a going concern, while the company is being kept as a going concern during liquidation process, those are also some cases where this would be definitely a concern. However, I think there was no dispute regarding the pre-CIRP period employees that is governed by section 53(1). That's something which is no dispute. So this was one concern, and the observations. Now let us try to see the other part of the observations. The Supreme Court further said, now, so far as submission on behalf of the appellant, that as per section 20 of the IB code, even as per the decisions of this court, decisions of the Supreme Court in the case of Swiss Ribbon Private Limited and Gujarat Urja Vikas Nigam Limited versus Amit Gupta, the RP is under mandate to manage the operations of the corporate debtor as a going concern, and therefore it is believed that during CIRP, the corporate debtor was a going concern. Further, the Supreme Court said that this is what is the argument of the appellants, that in the case of Swiss Ribbon and Gujarat Urja, even the Supreme Court has held that the company would be deemed to be under a going concern. The Supreme Court said that it cannot be accepted. It is true that section 20 of the IB code, it is the duty of the RP to manage and run the operation of the corporate debtor as a going concern. However, the words used in section 20, it says the interim resolution professional shall make every endeavor to manage the operation of the corporate debtor as a going concern. Therefore, even if it is found that the corporate debtor was not a going concern during CIRP, despite best efforts by the resolution professional, it cannot be presumed that still the corporate debtor was a going concern during CIRP period. It depends upon the facts of each case. So, like while arguing, the workmen and the employees, they were also depending upon the observations of Honorable Supreme Court in Swiss Ribbon and Gujarat Urja. However, the Supreme Court said that the section 20 is very clear that shall make every endeavor, but that doesn't mean that it was kept as a going concern and all parts of the company was kept as a going concern. So this is where we finish this part. Like this, what about the salaries and workmen during the CIRP period? Now, a little further, then we will take questions. Only a couple of sheets, and now we are only talking about the section 36, subsection 4, which says that any money, any amount due from provident fund, gratuity fund, or superannuation fund or pension fund shall not be considered as part of the liquidation estate. So the Supreme Court has observed in this case, now, so far as the dues of workmen and employees on account of provident fund, gratuity and pension are concerned, they shall be governed by section 36(4) of the code. Section 36(4) clause 3 of the IB code specifically excludes all sums due to any workman or employee from the provident fund and pension fund and the gratuity fund from the ambit of liquidation estate assets. Therefore, section 53(1) of the IB code shall not be applicable to such dues which are to be treated outside the liquidation process and liquidation estate assets under IB code. Further, section 36(4) of the IB code has clearly given outright protection to workmen dues under the provident fund, gratuity fund and pension fund, which are not to be treated as liquidation estate asset, and the liquidator shall have no claim over such dues. Just give me one more minute. I will actually come how the Supreme Court has finally clarified it. Therefore, the concerned workman and employee shall be entitled to provident fund, gratuity fund and pension fund from such funds which are specifically kept out of liquidation estate assets. So the Supreme Court, in fact, categorically clarified that if there are any funds in the provident fund, gratuity fund, pension fund, I'm not sure whether these funds are maintained by the company itself or it is maintained outside the company, but these funds are exclusively for the workmen and employees and from such funds which are specifically. And as per section 36(4) of the code, they are not to be used for recovery in the liquidation. So this is also clarified. They are not to be used for recovery in the liquidation. So I think this is a very It's a great clarification that these funds are not supposed to be used for the recovery by the liquidator, and the employees and workmen shall be entitled to provident fund, gratuity fund, and pension fund from such funds which are specifically kept outside the liquidation process. So these two issues, and finally what is held by the Supreme Court, Honorable Supreme Court in this case, I think already we've seen in our presentation that the wages, salaries, and salary of the workmen and employees of the corporate debtor for the period during CIRP cannot be included in CIRP cost. This is a held portion, provided it is established and proved that the IRP RP managed the operations of the corporate debtor as a going concern during the CIRP, and that the concerned employee workman of the corporate debtor has actually worked during the CIRP. And in such an eventuality, the wages, salaries of those workmen and employees who actually worked during CIRP period when the resolution professional managed the operations of the corporate debtor as a going concern shall be paid, treating it and or considering it as part of CIRP cost, and the same shall be payable in full. First, as per section 53(1)(a) of the IB code, this is the first held portion. Second held portion, considering section 36(4) of the IB code, and when the provident fund, gratuity fund, and pension fund are kept outside the liquidation estate assets, the share of the workmen dues shall be kept outside the liquidation process, and the concerned workmen and employees shall have to be paid the same out of such provident fund, gratuity fund, and pension fund, if any available. If any available, I'm highlighting it, and the liquidator shall not have any claim over such funds. So it is very clear by the Supreme Court that the provident fund, gratuity fund, pension fund, if there is any money, the liquidator cannot claim it, and that has to be, the workman dues has to be paid out of these funds. And it is also mentioned, if any, that if funds are available in these funds, the liquidator shall have no right over them. I mean, nowhere it is provided that if there is no money in these gratuity fund, pension fund, or provident fund, it is the duty of the liquidator to fill that fund first and then distribute to the other. It is nowhere mentioned in this order, which was the anomaly, and it started with the Moser-Beer judgment, and then it partially was clarified by Justice VP Singh in the case of the Savan Godiwala, the liquidator of Lanco Infratech. In that case, it was clarified by ANCLAD, but now this is the final order from Supreme Court that this fund is not to be, it is not the duty of the liquidator to fill these funds if there are no funds available in these three funds. Further, the Supreme Court observed that, as observed hereinafter, there are disputed questions whether in fact the IRP RP managed the operations of the corporate as a going concern during the CIRP, and there is a serious dispute whether the Dahej yard was operational during the CIRP or not. There is a serious dispute that the concerned workmen and employees at the Dahej yard and the concerned employees at the Mumbai head office actually worked during the CIRP or not, and therefore it is directed that let the appellants submit their claims before the liquidator and establish and prove that during CIRP, IRP, RP managed the operations of the corporate as a going concern, and they actually work. Now, since the RP in this case had done something where this controversy was risen, one, that the attendance was marked. Number two, they were not terminated. Number three, the company was like so-called, it was deemed to be kept as a going concern. So because of these things, there was disputes whether the company was a going concern, whether they worked for the company. So the Supreme Court directed the liquidator that the liquidator will take their fresh claims, and then the liquidator will decide whether this company was, or that part of the company or that location of the company was kept as a going concern. Second, whether this particular employee worked, and the fresh adjudication will be done. Fresh adjudication will be done by the liquidator. See, like it is, and the liquidator is directed to adjudicate such claims in accordance with law and on its own merits and on the basis of the evidence which may laid produced, irrespective of the fact whether the RP, who himself is now the liquidator, included the claims of the appellant being wages salary during CIRP. Now the Supreme Court has said irrespective of what he did, whether he uploaded the CIRP cost to IBBI, whether he presented in the minutes of the meetings or not, whether the attendance was being marked or not, irrespective of all that, he has to do it afresh. What I think that this might be even the spirit in all other cases. In most of other cases, even the liquidator might have to do this. Like whether this claim of the salaries and wages during CIRP, that has to be that has to be adjudicated freshly. And then this is a new duty on the liquidator. This is the direction of the Supreme Court. The liquidator is directed to adjudicate such claims independently. Independently means irrespective of what even he himself was the RP. He has to now do it independently. If it is found that in fact the RP managed the operation of the corporate as a going concern during CIRP and the concerned employee workmen actually worked during CIRP, their wages and salaries be considered as included in the CIRP cost, and they will have to be paid as per section 53(1)(a) of the IB code in full before distributing the amount in priority to others. The aforesaid exercise shall be completed within a period of 12 weeks from today, and such amount shall be paid out of the amount which is directed to be kept aside earlier by the adjudicating authority, appellate tribunal, and therefore by this court. Till such claims are adjudicated upon, the liquidator is directed to keep aside the said amount exclusively to be used for workmen and employees' dues, which is to be paid on adjudication. So earlier that money was kept aside, but now it has to be adjudicated. So this is like understanding it to a great. Now let us try to see first of all the new duties on the IRP and the COC. The new duties on the IRP and the COC is that in the very first meeting, or whenever the CIRP starts, the IRP would definitely take an inventory of the employees, workmen, status of the company, who is required for keeping the company or that part of the company as a going concern. That list has to be presented. That list has to be presented in the COC meeting, and it has to be approved. So in case it is not approved, I believe it cannot be considered CIRP or RP code. Second, in COC also has to be very, very particular, because once the COC approves it, then it becomes the duty of the COC to contribute and let the employees and the workmen be paid in case they have approved their salary as a CIRP cost. Third, in whatever existing cases are, in case the same spirit is copied, then I think most of the liquidators will have to adjudicate their claims afresh, and considering whether that part of the corporate debtor was kept as a going concern and whether the person, the employee or workman has actually worked in that period, then only it would be paid as a CIRP cost. So this is the new rules, these are the new duties casted upon IRP, RP, liquidator, and the COC. The COC also has to work on these issues, because I think it's a Supreme Court judgment, so it can be considered as final. So Ankit,
great. You can just make me the host, because I'm not able to switch on my video back. There might be some setting changes required, which we can take up later. I will also you can just.
How do I make you as host? I'll just.
There is a ... against my name.
I've done that.
So that's the only. So now a few questions from one question from Madanji, that in case of workmen union, if in CIRP period and the requirement of workmen is only say 40, whereas 150 workmen are on the roll, then in such scenario, how do you reduce the workforce under IBC? So this is a very, very difficult practical question, that you have 150 people on the rolls. How do you as an RP understand which 40 to retain? So I believe the RP should perhaps understand which 40 are required by the company's existing management that they want to choose to retain, which are the most senior, which the employees which perhaps have the most technical knowledge to continue the company as a going concern. And this is required especially in case the COC is not willing to approve more than 40 people who are really required to keep the company as a going concern.
See, my understanding about this, the assessment of who is required and who is not required. The IRP will definitely have discussions with the suspended management, the key managerial personals, and based on their recommendations and based on the key managerial personal's recommendation, also reasons that particular list will be placed in the COC meeting, probably in the very first COC meeting. And in case it is approved, okay. In case it is not approved, then the workmen and employees will be very sure that they will not get their salaries or wages for this period. So they will not work. As regards the unrest is concerned, of course, that's a separate issue. But as far as the workmen dues are concerned and whether it is practically to remove the workmen or not, that's totally a separate issue. But the moment we have a Supreme Court judgment in hand, it is very difficult for the liquidator or the RP to keep paying the salaries of those people, or even to keep accepting the claims of those people who are not working and who are working at that part of the company which is not operational. So how to remove? One, section 28 says that you need COC approval. Two, it is for you to pass an office order as an RP, and it is for the workmen to see whether they leave or they create some unrest. If they create some unrest, then the local authorities will get engaged, and the local authorities should be told that this is a Supreme Court order and this is what is the law, and we cannot do anything beyond this law.
So
Then
COC has to take a decision. Either COC has to approve a removal or it has to approve a continuation. Without that, it will be a decision in limbo, which will affect the going concern of the company. So I believe that is something that is the locus, is the primary idea. Ravi Sankarji is asking, salary is for n time scale basis and not piece rate. For a time scale basis and not piece rate, meaning that I am paid for 10 to 5 attendances whether company is able to provide me job. So I believe the idea here is that it is not only about attendance, so there has to be going concern. So in case there was a provision here that somebody was marking attendance also but not doing any work, the main idea is that the COC did not approve those salaries. Had the COC approved those salaries and the attendances were marked, and even if there was no work to be done, the salaries would be payable and that CRP cost would have been allowed. That is my interpretation.
Yes, you're right, Ankit. The COC's approval may be correct or incorrect. Once the COC approves, I think that was the assurance given to the employee that it will be paid. And later on, I think it cannot be reverted back. Even the law today, as laid by the Honorable Supreme Court, if the COC's approval is must. If the COC's approval is there, I think that's final. But then the COC will not give approval in case the COC thinks that it is not operational, it is not a going concern, and the person is not working.
So the idea is that the COC has to understand that for the resolution applicant who might come for taking up the company, the existing employees are a pre-requirement for that resolution applicant to take it as a going concern. In that circumstance, the COC might even be ready to invest in paying salaries to some employees, even if there is no work during the CRP period. That is also something I believe which is important to be understood here. That maybe the current work is only allowing 40 employees to stay, but then if a resolution applicant comes in, he might be wanting 150 trained resources, and that might be valuable for him.
So in case the COC thinks that the going concern of the company would be the status of the going concern would be adversely impacted in case the trained human resources are not with the company and the value would be diminished. So the COC can take a decision that we will consider this as a going concern and we will consider these people as working and their salary would be paid. In case the COC approves it, I think fair enough. But the primary issue is that the COC must approve it after considering their value for the company. Maybe the value for the company is also for increasing the value of the company in case the trained human resources are available. That is also the value for the company.
Right. Arunji is asking, kindly clarify the meaning of managing business as a going concern, whether it means obtaining order, purchase of material, achievement of sale, production, etc. Maintaining going concern would ideally mean that you can do business. One can, if the entity is a manufacturing concern, continue the manufacturing. In case the entity is a trading concern, continue the trading. That would be the basic idea. The continuation of transactions that the company was doing for its for keeping its or for continuing its business. Anything to be added here apart from what I said?
Yes, Ankit, I also would like to add simply manufacturing, purchasing, and or selling is not the only criteria. I will give an example of a power plant which was set up, and power plant is not operational as of now, and the power plant is waiting for the power purchase agreement. Now, in case I do not keep staff for maintenance, I have to keep, because there is a lot of maintenance required for the plant. There is no order, plant is ready, but I have to keep people for maintenance. In case I don't keep people for maintenance, that means that the plant will diminish. The status of the company when I took over as IRP, whatever the status is, it was a well-maintained state plant. So in case I stop maintaining, that means that I'm not keeping the company as a going concern. So
So
even if there is no sale purchase, maintaining also.
Maintenance of the capacities which the company has, even if there are no orders, you are saying, is also important, so
Yeah,
that
it is also important.
it does not destroy value of the value for those assets as a business.
So whenever we say that the company is being kept as a going concern, that we even preserving and protecting the value of the company, value of the asset, is also a cost for keeping it as a going concern. And if that needs some employees and some workmen, that is definitely considered to be a CIRP cost.
Now, another important question is that, say there is a company which might have kept a gratuity fund, or all the leave encashment and other payables have been kept by them in a different fund, but only up till a certain X date. And since that date, say there are 3 years before the CRP commencement date, when the company had those employees on its rolls, where it never contributed to those funds. So in a way, there might be a deficit in that fund for the payment of those retirement benefits to the employees which were on the rolls as on the CRP date. Then, of course, the next stage is that the employees continue to be part of the company during the CRP date, after the CRP date, and uh, in case here there is a resolution applicant who comes in and who says that, okay, I will take over the company. There, the resolution applicant can very well, in my opinion, say in the resolution plan that I will bear the cost of retirement benefits of the existing employees from the date of the passing of the resolution plan by the NCLT. And before that date, the retirement benefits will not be payable by me. That is something that perhaps can be made part of the resolution plan. Now, in this complicated scenario, is this then an accepted idea? And because the Supreme Court order, as far as I could read, was not very clear on what will happen in case the fund has a deficit. In case the fund has a deficit to pay these dues, the workmen will not get those dues at all. And
see, like what the Supreme Court has said, Ankit, is let us see the definition of workman. Definition of workman under the IBC has been taken, had gone to the definition of workman to the Companies Act, and then from the Companies Act it has gone to the Industrial Dispute Act. So this is the kind of the definition which is being used for workman dues. Now the workman dues includes all the retirement dues, leave encashment, gratuity, everything is included in the workman dues. So my suggestion, when the workman files their claim at the commencement of CIRP, they should also file their claim for the gratuity which is due to them. I mean, I have seen if the workmen are not filing their claims, the IRP must consider, because see, the amount of gratuity is also available in the books of account. And in case we see the regulations, it is also provided that even if the workmen are not filing a claim, the workman's claim can be considered from the books of account by the IRP. So therefore, the gratuity claims, the claims of pension fund, the claims of provident fund, that also can be taken by the IRP from the books of account, from the provisions of the gratuity made in the financial statements, and that would be considered as workman dues claims as on the commencement of CIRP, and will actually be dealt with under section 53(1), clause B and clause C. So the Supreme Court has not given any special treatment to gratuity fund, pension fund, or superannuation fund. What is important is that the filing of the claim, admittance of the claim as on the date of CIRP, and subsequently as on the date of liquidation. No, what I'm trying to say now is that during CIRP, if the COC is not accepting, say, a bunch of 200 workmen, if the IRP or RP is not accepting them as workmen, that actually means that their claim being a workman of the company will continue, but their claim as a CIRP cost will not be there. So if they are on roll and the company has gone into liquidation, so first of all, their claim up to the CIRP cost in case the company is gone for resolution, that will be dealt in the resolution plan. However, whatever is minimum due to them under Section 53, that has to be paid for a compliant resolution plan. So if the minimum as per Section 53 is something which is X amount, which is due to workmen and employees, that has to be paid. Anything over and above in a resolution plan, that has to be accepted. So nobody can say that the workman has now been taken over by the RA, so their gratuity has now passed on to RA. No, the gratuity claim has already been submitted, or if it is not submitted, it should be admitted suo motu by the IRP and the RP. So once all their claims of superannuation, gratuity, pension, provident, everything has been admitted by the RP, then the RA would pay only whatever has been committed in the resolution plan. Now coming to the liquidation, during liquidation, in case the employee is still on the roll, the liquidator will admit one part of the claim as CIRP cost and the other part of the claim as workman dues and employee dues. So they will be dealt with under Section 53 1B and 1C. So I think most of the anomalies has been settled. Most of the anomalies. I mean, there is no anomaly now for the pension fund, gratuity fund, because the claim has to be admitted by the IRP as on the commencement, even if it is not added by the employee while submitting their claim. So the resolution applicant, successful resolution applicant, will pay whatever is agreed by him. So he is not supposed to take over the entire gratuity claim or entire superannuation fund or entire pension fund. He will only take over whatever he has admitted.
I'm saying, so I understand what you're saying, and I think this makes sense. But then this, of course, is a lot of work for the IRP, including understanding the books of accounts, understanding what is the money lying in the fund that might be available, and netting that fund off when it comes to the company's liabilities which are still pending. Then looking at the understanding the date of employment of all these workmen and trying to understand that from records, because the gratuity liability will always be dependent on the date of joining of that employee. All these fact checking and verification of these claims is, of course, a very, very complicated exercise.
I think we can take some very clear questions which are there. I think still the participants are asking questions. That's very important for us, and we feel happy when the questions are being asked.
Puneetji is asking if in the current CRP there is a fund to pay salary but not paid by RP, and application for 12A and liquidation has to be decided by NCLT. Can post CRP period salary be refused as per the discussed judgment?
Yes, I like in this particular case, ABG Shipyard, I have said that the RP had taken the attendance. RP has been asking money from the COC for payment of salaries and wages. The COC was saying that the money is not available. The RP also confirmed that everyone will report. RP also sent a communication to all the employees that they will report. RP have done everything, and now the Supreme Court has asked him to do it everything again. The Supreme Court has put a new responsibility on the liquidator, who was earlier RP, that you take the claims afresh, consider the claims and adjudicate afresh, keeping into consideration whether the company was kept as a going concern, that part of the company was kept as a going concern, and whether that particular person worked or not. I believe that spirit can be copied everywhere. Irrespective, because in that particular case, even the CIRP cost was uploaded in Form 1, 2, and 3 to IBBI.
So the procedure was followed. So many things were actually confirmed that is part of CRP cost, but just because it was not finding approval in CRP, it was decided. But the procedure was followed. Yes,
procedure was followed. But yes, please.
Yeah, Sandeep ji then says that if plant closed before CRP and the employee is on roll, it is considered as going concern. If few people in accounts are helping RP, can only their salary be considered as CRP? So I believe we have already said that
Yes.
that is of course possible. Secondly, we are saying that it is the duty of the RP to put the facts before the COC and let the COC take the final decision to whether they want to bear the cost of the other employees or not. But how far they're helping the process of keeping the company alive, those facts should be brought forward. So as sir said that maybe some employees are maintaining the plant and machinery, maybe those employees are also critical to be kept for the going concern possibility of the company.
Yes. Yes.
Ranjan ji is asking sale of business as a going concern and sale of company as a going concern. The distinction, please explain. I think this is a question beyond today's topic.
Yes.
This is
Yes.
about liquidation. Maheshwara ji is asking that
No,
in this,
we'll come up with a subject
yeah,
specifically
yeah.
the sale of a company as a going concern and the sale of the business as a going concern. We'll take it as a clue for the new subjects. So we'll come up.
So how to deal with the claim of PF authority during liquidation, whether the same will be treated under section 53(1)(e) or under section 36(4)(3).
So
Claim of the PF authority.
the claim of the PF authorities is basically there are two kinds of claim of the PF authorities. One, the money which goes to the workman's account. One, the money which goes into the workman account, that should be treated and that would be treated as workman's dues before the commencement of CIRP. And the second part of the dues of the PF authorities is their penalties and interest. Now the penalties and interest will go to the subclause E, and anything which will go to the workman's account, which will be withdrawable by the workman, that will be considered as workman dues and will be dealt with under section 53(1)(b) and C, respectively. So there are two parts of the Provident Fund claims from the Provident Fund Commissioner, and that should be assessed very carefully.
So I believe that sums up all the major questions, and with also time, we're 15 minutes above our scheduled time. So it's a good topic, good discussion. I think this format is a good format. We should keep this short format to discuss one topic at length.
Somehow it could not stay short because this judgment was very important, and we thought of sharing our understanding. So I think we should thank our participants, and it is our pleasure to be connected with all of you. And as we always say, that this is our way of learning. So we should conclude this, and thank you very much. And
thank you, everyone.
Every Sunday between 4 to 5, please mark your calendars, and we'll definitely come up with some of the other subjects like this. So we are very happy to do this, and we will continuously do this. Thank you.
Thank you, everyone.
Thank you very
much. So much.